Okay, let's go ahead and get started as people are trickling in. Thank you all for being here today. My name is Melina De Bona, and I'm an attorney at the Earth Rights Research and Action, or TERRA program at NYU Law, including its Climate Law Accelerator, which you might know as CLX. CLX is a global collaborative hub for research, advocacy, and strategic legal action on the climate emergency, working with and connecting scholars, impacted communities, scientists, and legal practitioners from around the world. CLX initiates and supports the legal strategies, tools, and ideas needed to secure urgent and ambitious climate action. So we're here today for two reasons. Some days ago, on July 3rd, the Inter-American Court of Human Rights issued an advisory opinion, number 32, in response to a request by the governments of Colombia and Chile. In doing so, the court took a historic step forward for climate justice, setting out for the first time a clear and authoritative interpretation of states' obligations under the American Convention on Human Rights in the face of the climate emergency. The request asked the court to answer over 20 questions, touching on the obligations of states, both individually and collectively, to prevent, respond to, and remedy the human rights harms caused by climate change. AO32 addresses these questions with depth and quiet ambition, offering a legal framework that has the potential to guide courts, governments, and advocates across the Americas and far beyond. CLX is honored to have participated in the process, offering both written and oral submissions at the hearing in Barbados. We did so as part of a broader regional and global effort to support the court in grounding its opinion in what is a fast-evolving field of law, science, and the lived realities of communities on the front lines. This moment, we think, therefore offers a unique opportunity to reflect on how far the field has come, and also where it's heading. That is precisely the focus of Cesar's new book, which we're also launching in this webinar. It's titled Climate Change on Trial: Mobilizing Human Rights Litigation to Accelerate Climate Action. The book tells the 20-year socio-legal story of human rights-based climate change litigation. Based on an original database of the totality of rights-based climate lawsuits around the world, as well as interviews with leading actors and participant observation in the field, the book explains the rise and global diffusion of rights-based climate change litigation. It combines insights from global governance, international law, climate policy, human rights, and legal mobilization theory in order to offer a socio-legal account of the actors, strategies, and norms that have emerged at the intersection of human rights and climate governance. By proposing a broad understanding of the impacts of legal mobilization that includes direct and indirect, material and symbolic effects, it documents the contributions and shortcomings of human rights litigation in addressing the climate emergency. So the book is an open source resource for the field, as most of our resources are. You can find it on the CLX website, which the link is in the chat. There you will also find the accompanying CLX database, which systematically compiles all the rights-based climate change cases that have been brought before judicial and quasi-judicial bodies. Please note that the Spanish and the Portuguese versions of the book and the database will be published at the end of the month, and you can find them on the same link that we have placed in the chat. With that, I will now introduce the panelists and probably do no justice to their wonderful and long careers. So first we have Elisa Morgera. Elisa is currently serving as a UN Special Rapporteur on Climate Change and Human Rights. She's a distinguished professor of global environmental law at the University of Strathclyde, Glasgow, an adjunct professor in international and European Union environmental law at the University of Eastern Finland. Previously, she worked with the UN Food and Agriculture Organization in Italy and the UN Development Program in Barbados, and continued to collaborate with the UN and other international organizations as a consultant and independent expert. Then we have Theresa Amor-Juergenssen, who holds an LLM from the Geneva Academy of International Humanitarian Law and Human Rights, and has been called to the Bar of England and Wales. She's the lead of legal research and capacity building at the World's Youth for Climate Justice, and she's the co-founder of NICA, an organization of international lawyers and human rights defenders fighting to create a better world in Latin America and Europe. We then have David Boyd, who's a professor of law, policy and sustainability at the University of British Columbia, and served as the UN Special Rapporteur on the right to a clean, healthy, and sustainable environment between 2018 and 2024. As a special rapporteur, he filed amicus briefs in 15 cases, including the Inter-American Court of Human Rights advisory opinion on the climate emergency, together with the special rapporteurs on toxics and development. David's books include The Right of Nature, The Optimistic Environmentalist, The Right to a Healthy Environment, and The Environmental Rights Revolution. And last but not least, our own César Rodríguez Garavito, who is a professor of law and chair of the Center for Human Rights and Global Justice at NYU School of Law. He's the founding director of the Earth Rights Research and Action, or TERRA program, and of course its CLX, Climate Law Accelerator. Professor Rodríguez Garavito is an earth rights and human rights scholar and a field lawyer whose work focuses on international environmental law, indigenous peoples' rights, human rights, and more than human rights. So with that, we'll turn to the substantive part of the panel. So for the first question, I'm going to pass it on to César to get us started and set the field a little bit. So César, in chapter 3 of your new book, Climate Change on Trial, you explain that given the slow and cautious pace of the evolution of international law, the contrast of the rapid development of the rights-based climate litigation field is quite striking. In this context, you note that the involvement of the world's highest human rights tribunals in rights-based climate cases signals a consolidation of the field. So the question for you is, how does AO32 fit into that picture of consolidation?
Thank you, Melina, and thanks everyone for being here with us today. If we had more time for bios, which we don't, we would go through Melina's bio as well, because she played a pivotal role in both the submission that CLX made to the court and everything that we did in that research project. So really, this is a moment, quite a moment in the arc of the history of climate litigation and human rights. And it is striking that it's been exactly 20 years since the first complaint, the first petition was filed by the Inuit leader Sheila Watt-Cloutier and her lawyers before the Inter-American Commission on Human Rights. And 20 years ago, if you go back to the response from the commission, it was a 2-letter page saying basically that the commission didn't have a way to understand climate change as a human rights issue. It was a summary dismissal. Fast forward 20 years, and you have a 250-page and counting advisory opinion from the Inter-American Court of Human Rights. So the first message, and perhaps the most important message that I would like to convey with this book that we're launching, is that the law can change very quickly. So no matter what some lawyers and critics and even cynics would say, things can change very quickly, thanks to the work of many litigants, youth activists, judges, scholars, who have been pushing forward the idea, which was preposterous at the time. I do have in chapter 1 of the book some interviews with some of the lawyers who first kind of attempted these sort of legal actions before the court, and they told me that they were literally called crazy for understanding climate change as a human rights issue. Climate change was used to be framed, used to be understood as a thing for climatologists, for scientists, maybe for environmentalists, certainly for polar bears, but not for human beings and for human rights advocates, scholars, and lawyers. So this is really a historic moment in the arc of that history that the book tries to document. I'll just highlight 2 things in response to Melina's question. One is that the advisory opinion does a lot of consolidation. A lot of what the court says is basically a distillation of the body of law that's emerged over the last 20 years, both in Latin America and most of the cases, many of the cases. Latin America is one of the regions where we've seen most rulings and lawsuits on climate and human rights. So a lot of this is distillation from comparative law. Chapter 4 of the book does just that. And by the way, chapter 4 of the book and the whole book now is immediately outdated because of these events. But the aspiration, we knew that this was going to happen, so the book will be regularly updated. So I'll just give one example and move on to the second and last point. The idea that human rights has to have a forward-looking intergenerational component to it. That was not the case when some of us litigated some cases in the 2010s. Courts had a hard time understanding that unless the international human rights framework was updated to incorporate a key forward-looking component protecting the rights of future generations, that body of knowledge would not be relevant to deal with a phenomenon, a natural phenomenon like climate change that will unfortunately have its worst impacts in the future. So that is, and the court does quote from rulings like Neubauer in Germany to say just that. And finally, I'll say a lot of from my point of view, the key contribution of the court is that it specifies the content of many of the rights and many of the doctrines that were already kind of floating in the air in comparative law. So it's one thing to say that climate change litigation based on human rights are justiciable causes that should be reviewed by the courts, like many courts have said around the world. And it's another thing to go down to the details or exactly what rules of standing, what types of guarantees of access to justice, what procedural rights exist and should be followed by and protected by states, as the court does towards the last third of the advisory opinion. So that specificity is crucial, and I think it's going to be already is a key contribution to comparative law, together with with some inroads into topics that had been blind spots in comparative law, like adaptation. Climate adaptation had received a lot less attention from the courts, both domestically and international human rights bodies. And this court, spent quite a bit of time, I would say around a fourth of its ruling, mostly on adaptation issue, which is a very welcome development because so far it has remained a relative blind spot, especially when compared with the attention that climate mitigation has received in international law.
Great. Thank you, Cesar, for setting the scene. And so let's dive a bit more into the specific normative developments that the court makes. Elisa, this question's for you. I'm picking up on another well-known characteristic of the human rights and climate governance frameworks, in addition to the one that Cesar mentioned, that is that it's often perceived as being not really being future-looking. So another characteristic that we are aware of is that the human rights regime and the climate governance framework is often seen as very state-centric, right? And so this is true despite the increasing availability of data on historical emissions of the largest fossil fuel companies, and also the aggressive strategies that many of these companies have pursued to hide or deny climate science. So in enumerating the various obligations derived from the right to healthy environment and now healthy climate, the court includes states' obligations to regulate corporate behavior. So could you please unpack the content of that obligation, and where do you see the strengths and perhaps gaps? Looking ahead, what might be the next steps in the normative development of corporate accountability, given where the court has left us?
Yeah, thank you so much, Melina, for that important question. And thanks, Cesar and all, for having this early and important exchange of reflections on the Inter-American Court Advisory Opinion, which I think will keep us busy for a while to unpack all the elements. I think based on the earlier case law of the Inter-American Court, and in particular the 2021 decision on the mosquito divers in Honduras, there was a lot of expectation that the court would really delve not only into state obligations to regulate private companies, but equally private companies themselves and their responsibilities to respect human rights. There were indeed references in the advisory opinion to the carbon major database and more recent understanding of the individual contributions of specific companies to historic greenhouse gas emissions and how we have advanced in understanding their current contribution as well. And I think also significant engagement with the evidence around the multi-decade and increased today efforts of the fossil fuel private sector to disinform about climate change in terms of corporate capture. And there were very vivid testimonies during the oral hearings and in the written submissions. What we've seen the court doing is, in a way, also consolidating a lot of the work the UN special procedures have done in this area, particularly in the last few years. There's a very significant, almost textual reliance on the work the UN Working Group on Business and Human Rights has done. Interestingly, in an informative note, as opposed to maybe a thematic report on climate change and the UN principles, guiding principles on business and human rights. And so on the one hand, the court details quite to a significant extent the obligations of states to legislate and to regulate the private companies who contribute to climate change, ensuring effective processes for their due diligence, both in terms of environmental protection and human rights, requiring that necessity of access to information, drawing also on some aspects of my report from last year, and clarifying that states need to legislate in terms of requiring private companies to adopt effective measures to reduce their greenhouse gas emissions and contribute to mitigation more broadly, as well as prevent any further greenwashing and undue influence on public debates. There's also important references to the need to reform international investment law and state contracts with private foreign investors, and some reflections on the role of private companies themselves in terms of what they need to do to ensure their due diligence. What maybe could have been there more, and it was specifically argued before the court, was maybe specific attention to fossil fuel companies themselves. There is an indication in the advisory opinion that there are stricter duties for companies that create the highest degree of greenhouse gas emissions. And there's an interesting footnote 597 that speaks about particularly the Secretary General call relating to fossil fuel phase out. I think at the time that the court took this decision, unfortunately, some maybe more recent contributions were not available. And in my own report to the Human Rights Council this year, I contributed to clarify both state obligations in relation to legislation on the phase out of fossil fuels, as well addressing defossilization of knowledge, and very much looking at how companies themselves, fossil fuel companies, many of which are state-owned companies, and so actually directly engage state responsibility, need to make plans, very concrete plans for the phase out. In terms of next steps, I mean, we're definitely all ears and eyes waiting to see whether the International Court of Justice might say something more specific about state obligations related to the phase out of fossil fuels. And otherwise, I think litigation can really advance in this area, particularly in the basis of contribution of the latest attribution science. Just as my report was completed, there was a really groundbreaking article in Nature by Callan and Mankin showing how much advanced we are in the attribution of specific, for instance, extreme heat events to specific carbon majors, in relation to particular countries and the health costs of that. So I think we have a good basis, although not specific enough maybe to tackle the biggest cause of climate change, but more can happen in the very near future.
Thank you, Lisa. And I'm sure we'll see your name involved in those efforts, as we have seen it for the last year. So, okay, so now turning the questions over to Theresa. So, Theresa, the court made history through the people-centered process it has led in relation to AO32. The hearings, both held in Barbados but also in Brazil in 2024, were unlike any before the court. They were deeply participatory, centered on the lived experiences of those most impacted by climate change. So could you please speak to the role of the youth climate movement in shaping the AO process, and if you like, any of the other AOs? And in your view, is that contribution reflected in the final opinion, for instance, through the articulation of the intergenerational equity principle and beyond?
Thank you so much for this question, also for organizing this webinar, inviting me to it. It's very exciting to be here. And also, first of all, I really agree that it's been an extremely participatory process that the court has led in this very instance. I mean, it also received over 200 amicus briefs from, I think, over 600 different actors, and just the efforts of having the hearings situated both in Brazil and Barbados, so really at the front where the frontline communities are, at least a lot of them, in the Amazon and from in the Caribbean with the islands, I think has been so important. And of course, young people have formed a big part of this group and are a part of the group that is particularly affected as a result of this, especially because of the long-term impacts that climate change is going to be having on our futures, essentially, and also often the lack of being able to participate in decision-making processes because of our very young ages, even though these are the decisions that are made today are really the ones that are going to be impacting us. So it was really important for also young people to be able to participate, and a lot of them did. A lot of youth-led NGOs participated, child activists participated. Also, World Sea for Climate Justice, we submitted both written statements and then also participated in both of the oral proceedings, since we had submitted 2 written statements. And generally speaking, the arguments were focused on the differentiated protections that are owed towards children, youth, and future generations, and really on the principle of intergenerational equity, which has become, like, this has been rolling throughout all of climate litigation in the past few years, and has really been championed by youth-led climate cases throughout, if we're talking outside this process. And to the second part of the question, I very much think that the court did listen. Now, as Elisa has mentioned, I mean, this is a first reflection on this very comprehensive opinion, but I would very much argue that at the heart of the opinion lies the idea that from the climate emergency, we need to protect humanity as such. And humanity includes, the court considers it transversal throughout time. So it includes both present generations, but then also future generations, as well as, if we go into the more ecocentric approach that the court has really championed in its opinion, all life on Earth, that because humanity is part of the nature and the ecosystems. So this idea of humanity's protections throughout time is you can just see it throughout the entirety of the opinion, and really shapes, I think, a lot of the obligations that the court has elaborated upon quite specifically. You can see it in the rights of nature. You can see it also in the right to climate, and especially in the jus cogens aspect, so which was really based on in a sense, a nonsensical understanding that this is an emergency, that we need to protect the climate, we need to protect the environment, otherwise we can't protect human rights. It's a baseline condition, essentially, for the protection of all of human rights, of all of humanity. And this very comprehensive, long-term, transversal understanding has incorporated the principle of intergenerational equity in a very interesting manner. And yeah, in that sense, all of the efforts from young people championing and arguing intergenerational equity has, I think, really been reflected as part of the opinion that incorporated this long-term vision to protecting all life on Earth. So I think, just to bring it together, it's been a huge success. And I'm also very interested to go further deeper into it and understand the exact implications. But one thing that was particularly interesting is also on the collective titularity and the collective approaches to standing and to procedural rights that the court has incorporated, which also again brings in a way of incorporating the interests of future generations as part of everything that really that needs to be done in terms of climate action, but also in terms of being able to make these rights effectively be protected before the courts. Yeah, so this a few initial reflections, but I think it's been a huge success.
Wonderful. Yes, thank you for touching upon all those topics. And on a personal note, when César and I were in front of the court, some of the most impactful, oral comments to the court came from youth. Sometimes some of the older lawyers would tend to speak nonstop, and some of the judges were, dozing off because they were very, very long days. But when the youth got up to the front and gave their word, they really, really listened. So we thought that was really impactful. So now off to David. So Theresa did mention that the court recognized the existence of an autonomous right to a healthy climate. And that is a first time for the court and just generally for courts around the world. And as we know, this was derived from the right to a healthy environment. So naturally, David, the question is for you, and it says, how does the AO build upon its emblematic 2017 AO and the scope and content of the right to a healthy environment to imbue the right to a healthy climate with meaning? And beyond this, how does the court use the right to a healthy environment as a jumping point for normative development when it comes to, for example, the recognition of nature as a subject of rights?
Well, thanks very much, Melina. And let me just say at the outset, it's just such a privilege to be on a panel with three of my favorite human rights and climate lawyers in the world, César, Theresa, and Elisa. And nice to see you again, Melina. Thanks to NYU for putting this event together on short notice. This advisory opinion 32 is an incredibly comprehensive and compelling legal ruling that will have ripples across the world and across time. The way that the court has placed the right to a healthy environment at the center of this advisory opinion is really quite remarkable and builds on the court's 2017 advisory opinion, which looked more broadly at the relationship between human rights and the environment, identified the right to a healthy environment as fundamental for the existence of humanity. And I think that echoes what Theresa had said. This is a court that clearly, based on a comprehensive assessment of the scientific evidence put forward by parties to the proceedings, but mostly by the Intergovernmental Panel on Climate Change, has made it crystal clear that we are living in a climate emergency. And I think this advisory opinion is a compelling response to that scientific evidence. It is a climate emergency, it is a human rights emergency, and we must deploy human rights-based approaches to address this existential crisis. This new advisory opinion also builds on the court's decision in last year's case of inhabitants of La Arroya versus Peru, in which the court said that clean air and clean water are substantive elements of the right to a healthy environment. In this advisory opinion, as other colleagues have said, the court has acknowledged that a healthy climate is also a substantive element of the right to a healthy environment. And it defines a healthy climate as a climate that is free from dangerous anthropogenic interference, which really comes from the United Nations Framework Convention on Climate Change itself. And this right to a healthy environment, not only is it fundamental for the existence of humanity, but as Theresa said, it applies to both present and future generations. The court has made it crystal clear, and this is one of the most innovative aspects of the ruling, that based on the right to a healthy environment and other legal norms, that there is a peremptory norm against massive and irreversible damage to the Earth's life support systems. I mean, we talk about this in legal terms, but really this is what it boils down to, that humanity is causing this crisis which jeopardizes life on Earth, life for humans, life for more than human life. And the court is clearly responding to that in the most powerful way that it knows how, by articulating the parameters of the right to a healthy environment, the right to a healthy climate, saying that these apply to both future and present generations. Also saying that there's this really fascinating interconnection between the human right to a healthy environment and the rights of nature itself, whether that's forests, rivers, seas, or even the living and non-living elements of the environment. And flowing from all of these rights, of course, the reason why all of us are so excited about the application of human rights in a climate context is because human rights come with obligations for states, obligations for businesses. And the court, it goes through in extensive detail the obligations that are flowing from recognition of the right to a healthy climate. And those include, due diligence obligations, the obligations to regulate businesses, the obligation to have mitigation targets that are based on science, based on collective but differentiated responsibilities, based on the principle of progressivity, as reflected in the Paris Agreement. And I could go on, but I realize time is short. I want to just say that the court also says that what really must be a consequence of these obligations to respect, protect, and fulfill the right to a healthy environment is a new and truly sustainable model of development that reconciles human existence with the planet's ecological limits. And that to me is such a profound nugget of wisdom that's found in this advisory opinion, because ultimately that is the truth. Our population of 8 billion people moving quickly towards 10 billion people is pushing against those limits of the planet. And we must find a different pathway forward that reconciles human rights, human development, and ecological limits.
Thank you, David. I should perhaps end the webinar now that you finished on that very inspiring note. But no, just kidding. Okay, so we'll move on to another right that the court reinforced, we could say, or perhaps semi-created. So Elisa, this question is for you. The court affirmed a substantive and procedural right to science for all persons and elaborated on related state duties. So can you tell us how the court defined or perhaps redefined the notion of science, as well as the concept of best available science? And what implications might this have for future decision-making and policy?
No, thanks so much again for the question. And in a way, my response is really complementary to how beautifully both Theresa and David has reflected on, I think, the revolutionary content of the advisory opinion, which is that protection of life supporting system, protection of life on this planet. And in a way, it's still surprising to me, being by background actually an international biodiversity lawyer, how we're still struggling to this day, including when we were in Bonn a few weeks ago for the intersessional climate negotiations, to see that indispensable connection between protection of nature and the protection of the climate system as part of that. That is still not even a main or a sufficiently discussed element in our climate decision-making processes. And I think, including because of those decades of climate disinformation and obstruction, is not even common knowledge for many people. And that's crucial to make sure we understand what science we need, what kind of science we need present in decision-making places, but also how we can ourselves contribute to the protection of human rights in the context of climate change. So the human right to science, I was very happy to see the court engaging with that in very deep ways. I think once again, the court very much relied on many years of work by UN special procedures, spearheaded by a seminal report by Farida Shahid, former UN Special Rapporteur on Cultural Rights, but then there's been further clarifications by Alexandra Santaki, also Rapporteur on Cultural Rights. Currently, Marcos Orellana, Special Rapporteur on Toxics, and myself last year. Really focusing on how that understanding and access to science is a precondition for effective protection of all our human rights, who are based on that need to understanding what we need for our protection. I think what's very innovative in the reasoning and the spirit of the advisory opinion compared to maybe the work that has been done across the UN system is that boiling down the idea of a human right to science in the context of the climate emergency to a constant dialogue between different sources of science, Western science, indigenous science, local knowledge, and traditional knowledge. And seeing that as the only way in which we can legally, and also in terms of co-development of solutions, really grapple with the complexity and the interconnectedness of life-supporting systems that are undermined by our climate emergency. There are several obligations that then are spelled out about the role of states to protect the human right to science and as well combat against any efforts to undermine everyone's human right to science. So again, we go back to all the measures that are needed to address disinformation, misinformation, attacks to environmental human rights defenders, and that includes scientists. But also very much introducing, thinking about positive obligations, about ensuring that people have access to the benefits of our scientific progress, that our best knowledge around climate science and the climate emergency, including human rights, is brought into education as well as information. And I think to me, maybe the most, a very important aspect is then what it means in terms of international cooperation. And that leads me maybe to 3 key points in terms of what implication does it have, the human right to science, for, well, current and future decision-making and policy on climate change. Well, the first is that we often speak about technology transfer in terms of responding to climate, both for mitigation and adaptation purposes. But in fact, we need technology co-development. We need processes that are truly where we set the premises, we set questions, we challenge assumptions across all relevant and diverse knowledge systems, and then co-develop solutions, which is also a way to overcome very well-known barriers related to intellectual property rights or imposition of solutions from the global north to the global south that are not fit for purpose. The other is thinking about how we need urgently to evolve our decision-making places, be that the climate COP, be that other international fora where we're taking decisions on the climate system. I'm thinking about the plastics treaty negotiations, and the IPCC. The IPCC has just launched a call for experts to contribute to methodological workshops, which should be the way in which they build their own capacities to really, hopefully, live up to the vision that the Inter-American Court has just shared with us. So much work to be done. We have people who are experts in co-development and indigenous scientists who can support all of us in that process. And we just need to make sure that they take center stage and the driving seat in those processes.
Great, thank you, Lisa, and absolutely in setting out the work that comes out of this opinion. That's something that I am sure CLX and also the More Than Human Rights, the Moth Project, would love to get involved in as well. So Theresa, going back to you for another question. So AO32 is part of a broader wave of climate-related advisory opinions, with the International Court of Justice set to issue its own later this month on July 23rd. Youth movements have been central to pushing for these opinions and also developing them. So as these landmark decisions unfold, what is next on the youth climate movement's agenda?
Thank you very much for this question. This is, of course, the question we've been asking ourselves for the past few months, really. And it's very important. I mean, yesterday was a huge day for all of us because we learned that the ICJ advisory opinion would be issued in 2 weeks on July 23rd. And it's so for World Youth for Climate Justice, I mean, we've been working on this opinion, on getting this opinion. This has been the whole purpose for the existence of our organization for the past 5 years approximately. So it's going to be a huge moment and very important. And I think once we have the ICJ advisory opinion, that means we've had 3 advisory opinions from international courts. We've also had the Klimasenioren case from the European Court clarifying certain standards in relation to the European system specifically. I think we're going to have this very interesting framework of clarification of the standards and obligations and the rights on the international level. So in terms of what is next, once we have that, I can summarize it in one word. It's implementation. So it's really trying to implement all the standards, the norms, the obligations that were set out and clarified in all of these opinions, which are based on binding legal obligations, and to make sure that are actually implemented and followed by states all across the world. And implementation can, of course, take a lot of different forms. There's advocacy and really talking to states, for example, and getting them to change their legislation, for example, their policy framework in order to align with their obligations as set out by the opinions. There's the negotiation efforts at the international fora, like COPs, really being based on these clarified legal standards. Litigation, as Cesar has already mentioned, I think that this will be another post-Paris. We've already had a huge increase in climate litigation, especially rights-based climate litigation. I think this might be another one of those moments where litigation can really increase and also further develop these standards and put them into specific national contexts and clarify how they apply in the different legal systems. And then capacity building is also a really important effort to make sure that people and all of the members of this huge climate justice movement know how to use these legal tools that have now been created in all of their climate justice efforts, essentially. Now, going back to the Inter-American Court opinion, I think what also was very interesting and leads to the implementation is that the court was quite ambitious in specifying how the different states have to adapt their domestic legal systems in order to be in line with the standards that were set out. And it was quite explicit in a lot of these things. I've already mentioned the collective standing requirements. For example, the court very much suggested that states actually have to adopt their legal frameworks to allow for collective standing, which could incorporate interests of future generations to be taken into consideration in these litigation efforts. So that's, for example, really, really interesting when we're also talking about litigation efforts. Also, the evidentiary standards, the court specified that evidentiary standards need to be more flexible in the climate cases in order to essentially allow for the burden of proof to be not as strict and actually allow for the reality of the climate complexity to be taken into account in litigation. Also, what was also particularly interesting is the rights of nature. The court quite strongly suggested that states the best way of adhering to obligations essentially is to actually incorporate the recognition of rights of nature into domestic legal systems. So all of this going back to, again, the domestic legal systems that need to be adopted to be in line with the standards set out. I think that's going to be really, really important and essentially the next step. And then we've also had the court talk a lot about the procedural obligations from access to justice, participation in environmental decision-making processes, which is so important that everyone, the entire community, those most affected especially, is taken into account when all environmental decisions are made. So really making sure that this is enforced and that the youth and indigenous communities and frontline communities are taken into account, can effectively participate, is going to be huge and essentially really, really fundamental. The court also, and this is my last point, on the procedural obligations, it made very interesting connections between environment and democracy, and essentially the idea of environmental democracy, where it also suggested that states really have to provide mechanisms to integrate the interests of both nature and future generations into their climate actions. So all of this needs to be taken into account, made sure that states actually start following the obligations as set out. And in that sense, yeah, going back to implementation, this is the next step. And the fight that we started in order to get this opinion, all of these opinions, is now going to continue. And now it's gonna get really serious. Let me put it like that. Thank you.
Thank you, Theresa. Yes, as Theresa mentioned, there's quite a bit of work, and I think that the court, the AO, did a good job in setting up, but due to its breadth and its ambition, much of the work that comes ahead. But so, David, question for you. Despite being celebrated for this breadth and this ambition, no decision is without limits. So, from your perspective, what gaps or weaknesses stand out in the AO? And are there areas where the court could have gone a bit further, other than the ones that we have already mentioned, of course?
Yeah, thanks very much. It may surprise people, but when I first got the decision, I didn't do a search for right to a healthy environment. I actually did a search for fossil fuels, and I was surprised at how few references there are in this advisory opinion to the fundamental issue that is before us. If we want to tackle the climate emergency, we must rapidly accelerate the phase out of fossil fuels. And yet, as Elisa mentioned, to have the only reference to fossil fuel phase out in a footnote 597 just came as a kind of, I would say that's probably the most disappointing part of this advisory opinion. The court does talk about many state obligations that are related to and that implicitly require the phase out of fossil fuels, but it would have been so much more powerful to say that in crystal clear terms. There is one specific mention of the requirement to accelerate the elimination of short-lived climate pollutants. That's a very important issue in terms of addressing climate change and the climate emergency in the short term. But the broader need to phase out fossil fuels, I mean, my God, the science is crystal clear on this. We have study after study that proves conclusively we cannot burn the existing fossil fuels. So therefore, how can it possibly be lawful to continue to explore for new sources of oil, gas, and coal? So that would be what I would say is like one of the shortcomings of this advisory opinion. The other, and I think this may be equally important, and it's kind of shocking that we haven't mentioned it thus far in this webinar, is the issue of loss and damage, the issue of compensation or reparation for the millions of people living in small island states and other climate vulnerable nations for whom the climate emergency is not a distant threat, or an emerging threat, but a current threat that has caused immense damage to their lives, their health, their families, their communities, their livelihoods. I mean, at the People's Assembly at The Hague last December, which was a parallel process to the International Court of Justice hearings, we heard extraordinary firsthand accounts from people all over the world about how the climate emergency was disrupting and damaging their lives. And there's very little guidance in this advisory opinion about the critical imperative of making the big polluters, the historical emitters, the large current emitters, pay for those losses and damages. And there is a mechanism set up through the climate convention process to establish a loss and damage fund, but that has only got a pittance of money in it, something on the order of a few $100 million, when we need literally hundreds of billions, if not trillions of dollars, to pay for the extensive loss and damage that's already been inflicted. And the last thing that hasn't been mentioned on this really fascinating discussion, and which I'll give credit to the court for, is they talk about, as I mentioned earlier, it becoming a peremptory norm of international law that you cannot inflict massive, irreversible damage on the environment or the climate system. This comes very close. The court didn't say it, but this comes very close to the international definition of ecocide. And I think that is another way in which this advisory opinion will be harnessed by the proponents of making ecocide the fifth Rome Statute crime, because that's another tool in our toolbox that has both compelling legal and cultural influences. Thank you.
Thank you, David. And that's a great setup for our last question. So this one is for Cesar to wrap us up in terms of the discussion. So in the book, Climate Change on Trial, you walk the reader through the potential future of the rights-based climate litigation movement. So given the current momentum, including the advisory opinion, but also the gaps left, similar to what David and Theresa and Elisa have mentioned, what trajectory do you see ahead for the field? And what key gaps still need to be addressed by courts and litigants alike?
David just mentioned loss and damage, so I'll start there because in chapter 6 of the book, in the concluding chapter, I mentioned three major gaps in the field. One is adaptation, the second one is corporate responsibility, and the third one is loss and damage. I think, as my colleagues have said here in their panel as well, that the court did a good job at addressing and filling gaps when it comes to adaptation and corporate responsibility. A lot more has to be done, but there's only so much that any given court can do, and this one has made considerable progress towards filling those gaps. The loss and damage blind spot is still there, as David said, so I won't go into that. I hope and I fully expect that the ICJ will say much more about it, because that was one of the key topics that it was presented before the court in the petition to hand down that advisory opinion. Going forward, I see two potentially different and even contradictory trends. One is, and this is pretty predictable, that there will be a flurry of new legal actions leveraging the new doctrines or the specified doctrines that this advisory opinion offers. So what I would expect is that we will see a multiplication of the proliferation of legal actions of the sort that we have seen in the last 10 years or so, ever since Urgenda and other initial cases made it clear, and some courts like the Dutch Supreme Court made it clear, that climate change was indeed a human rights issue. In the book, I look at all of the cases of this sort, all of the climate actions filed before domestic, international, judicial, and quasi-judicial bodies based on human rights arguments. The book, the empirical aspect of the book ends. The cutoff date is December 31st, 2024. And there were, up until that point, 467 such cases. I fully anticipate that there will be again, a proliferation of this sort of legal action going forward. And the good thing from a normative perspective is that we will have even more granular arguments being made before courts throughout the Americas and beyond that will leverage the specific doctrines that this court has laid down in the advisory opinion, which is the movement, the trend that comparative law and international law has followed over the last 20 years. And I know that because David and Elisa won't say it, I will say it here that the special rapporteurs, of course, have made a crucial contribution to the further specification of those legal norms. If you look at what happened between the mandate of John Knox back in the early 2010s and what's happened now with Elisa's landmark report on fossil fuels, is that the special rapporteurs have build on the work of their the predecessors and gone deeper into what those high-level obligations means in terms, for example, of phasing out fossil fuels. That is welcome. That is exactly what you need in terms of legal traction to advance climate action. Now, the second trend that I see is the risk, the flip side of that trend of specification and the success of the idea that legal actions can be framed in terms of human rights and can accelerate climate action. And this is putting on my sociologist's hat, any successful field risks becoming isolated and risks developing its own blind spots. So my fear is that we will continue to we will see this type of climate action based on human rights as an end in and of itself. That risks missing the opportunity to link this normative development with what Elisa said and what David also and Theresa mentioned are adjacent but deeply interrelated normative gaps and normative opportunities as well. For example, all the work on biodiversity, all the work on rights of nature that now the court opens a door towards. So, and all of this is happening at a time when the legal framework that sparked many of these legal actions based on human rights, meaning the Paris Agreement and the Paris Framework, is in deep trouble. Many of these cases were framed as ways to give the Paris Agreement legal traction on the ground, to translate those non-binding NDCs into binding commitments at the local level, at domestic level. But that system is in crisis. It's geopolitically, of course, I don't have to remind anyone here what the circumstances are. So we need to go beyond Paris. We need to go bold, to be bolder and find new ways to frame the climate emergency as one that relates to the crisis of, or the emergency of life on Earth, as David and Elisa mentioned earlier. So going beyond what's been achieved is, to my mind, as important as taking advantage of all the contributions that the court does in distilling the existing work that's happened over the last 20 years.
Thank you, Cesar. Thank you very much for that. And so I am aware of time. We have about 5 minutes. And so I encourage everyone in the audience to throw any question you might have for any of the panelists in the Q&A chat. We have one question so far, and I'm going to open it for all of the panelists. So whoever wants to chime in. So the question is, the International Court of Justice will adopt its own AO on climate change on the 23rd of July. Will this AO 32 influence the ICJ AO, or is it unlikely due to time pressure? So I think we have touched upon this a little bit already, but I would invite the panelists to discuss maybe a broader point about how much do you see that the climate litigation and also just climate negotiation movements, how much do experts talk to each other and how much do opinions influence each other? Cesar's book touches upon this, and he had to run, by the way, because he had to catch a flight. But I will say this because I'm sure he would have said this. His book touches upon how collaborative this field is in comparison to other fields of international law. And so I invite Elisa, David, and Theresa to elaborate on this. Go ahead, Theresa.
Thank you. No, happy to jump in with some thoughts. Of course, no one, first of all, it's impossible to know what exactly the judges are thinking and to what extent how far they even are already with the process, right? Generally speaking, though, as a very general thought, the role of the International Court of Justice is to harmonize different branches of international law. And I am sure that they're going to, they know this opinion was coming, they knew about it, and I'm sure they're going to be very much paying attention to the opinion and take it into account. Of course, I don't know to what extent. Now, this is, of course, also, though, conditioned by a bit of the problem that of course, the Inter-American Court has a specific mandate to interpret the obligations under the Inter-American Convention on Human Rights, or broader, the Inter-American Corpus Juris. And a lot of what was said in the opinion is very much conditioned by the Inter-American Corpus Juris, by state practice in the Americas especially, and very importantly by the pro homine principle, which is very unique to the Inter-American system of human rights protection. So in that sense, there's a certain limitation to how much the pronouncements made by the Inter-American Court are relevant outside the scope. On the other hand, the court has given a masterclass, in a sense, on harmonizing the American Corpus Juris with other sources of international law, and has very much also taken into account the Paris Agreement, the UNFCCC, and a lot of course, customary international law, and a lot of these obligations. So there is, I think, some direct relevance also of a lot of the pronouncements made outside the scope. Some initial thoughts on this, but I'm sure they will pay attention, and I very much hope they're going to be paying attention and take it significantly into account.
Maybe just from my side, and yes, it's impossible to predict, but I think there is a stark contrast between the incredibly inclusive process of the Inter-American Court and what the ICJ could do, even if I think the oral hearings, gave me goosebumps. They were really powerful sharing of lived experiences of very deep, in some cases, decade-long compounded impacts on human rights of the climate crisis in those rooms, but not the same engagement with the lived experiences of so many sectors of society as the Inter-American Court has done. And to me, that deep calling for the protection of life on the planet really comes from those dialogues the Inter-American Court had, as well as the engagement with diverse areas of science. And I'm not sure to what extent the ICJ has been able maybe to engage with diverse sources of science. That said, it will be really interesting to see what the ICJ offers in terms of clarification of general international law, those arguments on jus cogens. Many arguments were made on jus cogens before the ICJ related to the human right to self-determination and discrimination, which I also addressed in my report on defossilization. I think also the reliance of the Inter-American Court on the general principle of effectiveness and how climate change is undermining almost every single treaty I can think of, all the objectives that states have agreed upon and their commitments. And this was very much the message from the IACHR advisory opinion last year. So there may be some resonance and hopefully an even broader thinking about the whole system of international law can be truly responsive to the climate crisis and some complementarities potentially with the Inter-American Court.
And I would just add, I agree 100% with what Theresa and Elisa have said. Also, it's really interesting to look back on the final day of the public hearings at the International Court of Justice. One of the judges asked one of the 4 questions, which was, is there a right to a healthy environment under international law? And if so, what is its content and relevance to these proceedings? And the Inter-American Court has answered that question in such a powerful way, as did the vast majority of parties at the International Court of Justice, that I can tell you I will have trouble sleeping on the night of July the 22nd because of a fear that the International Court of Justice will not be as bold as the Inter-American Court in putting forward a progressive, holistic, science-based interpretation of the right to a healthy environment that is rooted in our understanding that this is a climate emergency and that the future of human and more than human life on this planet depends on accelerated action to address the crisis. So fingers crossed, my friends.
Great. Thank you, David. And with that note, I realize that we are at time. I invite if people did not get their questions answered, feel free to send them to CLX, and we can find a way to make sure that those get answered, whether by email or in a future webinar. But I do want to thank all of our panelists and also the people behind this webinar for making this happen. And hopefully we'll continue the conversation and touch base to see where progress leads now that we have much work to do. Thank you all.